That's Enough Out of You podcast is sponsored by Todd John's Law. Unfortunately, bad things happen to good people, whether it's the result of an auto accident caused by the carelessness of another driver or being charged with a crime. Dealing with the aftermath of a personal injury accident or being involved with the criminal justice system can be extremely difficult. That's why, whatever you're facing, you should never go it alone. You need an experienced attorney who will stand by you every step of the way. Todd is experienced, licensed, trusted, respected, and guaranteed. No one will work harder or more diligently on your behalf, and he will personally handle your case from beginning to end. Located on Drinker Street in Dunmore, Pennsylvania, Todd has been representing the legal rights of Scranton and Wilkes-Barre personal injury victims and those accused of a crime for over 20 years. At Todd John's Law, the utmost priority is ensuring that your rights are always protected and that your case is resolved as quickly and fairly as possible so that you can move on with your life. Call Todd John's Law at 570-876-6903. With Todd John's Law, you will receive equal justice under the law. That's Enough Out of You is also sponsored by Casa Quattro Winery, featuring over 20 flavors of wine, from dry red, dry white, and fruit for your sampling pleasure. Casa Quattro Winery offers entertainment, parties, and private events. Now serving a full menu with a little something for everyone, including appetizers, salads, dinners, pizza, and desserts. Casa Quattro has some of the best live entertainment in the area, with comedy and karaoke nights and live bands. Check us out on Facebook and Instagram for all of our upcoming events. And if you mention the code OUTA, that's OUTTA, you get 15% off of your order. Located on Main Street in Peckville, Pennsylvania, call 570-382-3855 for more information. And we thank Casa Quattro Winery for their support. Hey, and welcome to That's Enough Out of You. I am your host, Bill Rader. And joining me, as he does each and every week here on That's Enough Out of You, is my co-host, Sean Kane. Sean, what's going on, buddy?
Billy Raids, how you doing today, buddy?
We're doing pretty good. I can't complain. Got decent weather here in the Northeast. And
it was great yesterday. Playing a little baseball yesterday with Nathan and getting ready for the season, buddy.
Sounds good. Hey, Sean, we got a great guest today. One of the authors from the book Chokeholds that we've been talking about. We've had Jim DiGenio, we've had Paul Blow, we've had Matt Crumpton, all co-authors on the book Chokeholds. And now we are very excited to have on the show Andrew Iler, who joins us. Andrew, welcome to That's Enough Out of You.
Hey, guys. Thanks for having me on.
Yeah, thanks for joining us. Andrew, where are you joining us from? Where are you located?
I'm up in Ontario, Canada.
Okay, yeah, you have that Canadian accent. I could tell right away.
I'll try not to say a boot or anything.
Bill's going to be talking hockey with you pretty soon, Andrew.
Exactly. I actually got my in the corner of my screen. I'm watching the Rangers Islanders right now. So I'll try not to get too distracted by that, but I am a huge Rangers fan. So Andrew, thank you for joining us. We really appreciate it. Sean, I know we have a lot of questions, a lot to get into with Andrew.
Yeah, we have a lot to cover, and we're going to really get into the legal aspect of everything. It's something new to our podcast. We're going to go down a different road here with Andrew. But Andrew, if you could just, take a minute here or two to just tell us a little bit about yourself and how you got into this, and then we'll get into the specifics of all this.
Yeah, no worries. I'm a lawyer. I've been practicing since around 2002, so the better part of 20 years. I practice mainly in corporate commercial law. I have a background in litigation. With respect to the JFK assassination, I, like probably everyone else, I watched Oliver Stone's amazing movie JFK, and that started me into reading books and just having a general interest in the history of the 60s. So that was early 90s, and then school and real life kicked in, and I continued to read, and I wouldn't call it research, but just fulfilling a real interest. And once I got my law degree, um, the JFK Act had been in place for quite a few years, and I became aware of the October 26, 2017 deadline to release all the files. And I got to say, going back to the Oliver Stone movie, that final screen credit of his film where it said that all the JFK, the millions and millions
Right.
of JFK assassination records were being held secret by the government
Yeah.
until I think 2029 or 2039 was on the ending credits.
Right.
I found that pretty offensive.
Absolutely.
I mean, Canada's a democracy, but the United States of America is one of the, if not the great democracies of the world. And
Supposed to be.
Well, for now.
I felt that that keeping these kind of records about such a massive part of American history was just not right. And so that 2017 deadline just stayed in the back of my mind. And I as it got closer, I started to read the JFK Records Act, and again and again and again, and it started to make a lot of sense to me, the way it was written and what Congress's intents were in passing that act
Right.
in 1992. And that's what my focus is. I mean, I'm interested in the assassination as a whole, but really my entire focus for the last 5 years has been in the legal aspects to the JFK case, and in particular the JFK Records Act, and how
Right.
it ended up just being blown to pieces by both Presidents Trump and Biden.
Right. And I do want to talk, Andrew, about, how basically two presidents, Biden and Trump, and the CIA, plot to negate the law with the JFK Act. But before we get into that, I've read the JFK Records Act, and I think, Billy, I think we could attach maybe a link to this podcast when it's out so people could read it, because I think everybody should at least look it over and have an understanding of what it is. But if you could just, Andrew, just explain to everybody, a little bit about what the JFK Records Act is.
Yeah, for sure. So in 1992, right after Oliver Stone's film came out, the American public went ballistic. Like me, they saw the ending credits that said millions and millions of pages of assassination records were going to be kept secret and not disclosed to the American public. And the American public reacted, just like they reacted after Geraldo Rivera played the Zapruder film in 1978 for the very first time publicly. When the American public saw the Zapruder film, they were outraged, and they contacted their senators and Congress people, and they demanded something be done, because they could see with their own eyes that, hey, what actually happened in the limousine in Dallas back in 1963 isn't what the government had been telling them. And so after Oliver Stone's film came out, the reaction was the same. The American people said, hey, this is not a democracy if we don't know what our own history is. And they contacted their senators and their Congress people, and they demanded that something be done about the JFK assassination records that were being held by the National Archives. And very quickly, on a bipartisan level, Congress acted, and they passed the John F. Kennedy Assassination Records Collection Act of 1992. And the act mandated that there was a burden on the government to release all the records unless they could show that that the records posed some demonstrable harm or potential demonstrable harm to some specific level of national security.
Right.
And those criteria are set out in 5 points under Section 6 of the JFK Records Act. And Section 6 is an incredibly important part of the act. And again, like you've recommended, listeners should pop onto the link that you'll provide in the notes, show notes, and go to Section 6. There's 5 criteria where the government can legally postpone the release of these records, like the identification of a living secret agent, or a current means or method of intelligence. And so we're talking about an assassination that happened in 1963.
Right. We're talking 60 years later. Like, we're supposed to really believe that there's an intelligence asset out there 60 years later.
There's always a loophole. And it's always the same thing, right, Sean?
It's crazy. It's just, but common sense. I mean,
right.
Well, I mean, hey, that being said, Paul Landis, Secret Service agent, just came out last year with pretty relevant information directly involving the so-called magic bullet. So I guess it is possible that that some intelligent asset is still alive and in a position to jeopardize the national government. But hey, that's what the criteria are there for. If there's a demonstrable threat, Section 6 allows a very limited number of criteria behind which the government can postpone a record. But they have to do that on a record by record basis. They just can't do what President Biden and Trump did. Which
right. And I want to
like
get into that, Andrew, because that's important, but before we do, let's, because I want to get into all that specifically and stuff, but let's talk about, so we got 2 presidents, Biden and Trump, who basically they broke the law with this Records Act, correct?
Well, they certainly, in my view, are not being compliant with it. Okay. So if you want to say that they broke the law, I guess that's one way of saying it. But the law is pretty clear. The president, the archivist, and Congress all have duties under the act. And these duties, when they're specifically laid out with no wiggle room, those are called ministerial duties. And if official or agent of the government that's specified in an act is told very specifically what they have to do, that's a mandate. That's a legal mandate, and that creates what's called a ministerial duty. And quite clearly, there are ministerial duties that apply to the president. And since 2017, both Presidents Biden and Trump failed to comply with a number of their ministerial duties.
So before we get into what Biden did on June 30th, 2023, let's talk about Trump first. 2017, all these files were supposed to be released in 2017, correct?
Yeah, that's right.
Okay. So
what happened? And I've attached a link to what the research community is commonly calling the Gannon memo.
Right.
And again, I suggest that your listeners click on the link and check out what Curtis Gannon, who was then in the Office of Legal Counsel to President Trump, wrote on October 26, 2017. The memo is essentially what Gannon purports to be a legal justification for the wholesale postponement of tens of thousands of JFK assassination records. And what the memo said really flies in the face of what Congress enacted in 1992 with the JFK Records Act. What Gannon said that caused the most damage is that he directly attacked the operability of Section 6. He said in one part of his memo that Section 6 ceases to be operable law as of October 26, 2017. Now, the it doesn't really justify why Section 6 ceases to be operable, but the impact that that had was that President Trump didn't need to comply with the criteria for postponement, and he did not need to follow the mandated standard of proof that's laid out in Section 6. So he was basically given a pass. He didn't need to give any real reasons for postponing the tens of thousands of records. Now, this is a little bit of a complex legal part of it. Section 6 has nothing to do with the operation of the Assassination Records Review Board, which wound up its business in 1998.
Right.
Okay. So you got to jump around between different sections of the Act. But one of the key parts of the Act is Section 12B of the JFK Assassination Records Act. And what Section 12B says is that all provisions of the JFK Records Act that don't deal with the operations or appointments to the Assassination Records and Review Board will remain in force. And it'll stay good mandated law until every single last one of the assassination records are released to the public.
Right.
Okay. So again, you go back to Section 6. Section 6 only sets out the standards of proof and the criteria for postponement. Has nothing to do, doesn't even mention the Assassination Records Review Board. Okay. So Section 12B mandates that Section 6 is going to continue as operable law until all the records are released. But what Curtis Gannon said in his memo was completely contrary to that. And so that's one unlawful part. You've got to read Section 6 and Section 12B in concert with each other, because again, Section 6 is probably the most important part of the Act, because it provides the only allowable justification for not releasing these records.
Right.
Okay. So it's a little bit confusing. This is why, lawyers have had trouble with dealing with the JFK Records Act. It's actually quite straightforward when you look at those two sections, Section 12B and Section 6, in line with each other, and then look at what initially President Trump did to justify not releasing those records back in 2017.
Well, let's talk about that, Andrew. So I think everybody will remember that, Trump was on Twitter and he's basically saying he's going to release all the files and he can't wait to read what's in them and all this. And then the next day, he says he's not going to release them. And I think he said something to the effect that he didn't have a choice or something like that. And there was recently an interview with Judge Neapolitano, said that he asked Trump about that. And he said, why didn't you release them? And Trump told him, if you saw something that, I don't remember the exact quote, but he said, if you saw what I saw, he said you wouldn't release them either, something to that effect.
Yeah. So I mean, here's the thing. There's a lot of rumor and speculation. So what I try to do as a lawyer is remove all of the hearsay, speculation, innuendo.
But the CIA did meet with Trump, though, right before he met. He didn't release these files, correct?
I do understand that Ray from the FBI and Pompeo from CIA,
yes,
did meet with Trump in the 48 hours or so before the postponement actually took hold. The only real thing that we can go on is the memo provided by Curtis Gannon as legal justification for the postponement. So the rest of it is hearsay, speculation. I mean, certainly if the head of the CIA and head of the FBI met with the president, and shortly before that meeting, the president's saying publicly, because we can go with that too, that he's going to release all of the JFK assassination records. They have a meeting, and then there's an about face. And to President Trump's credit, he did release a ton of records. He also kept postponed a ton of records.
Right.
I don't know why. His President Trump's memorandum, though, it failed to do one really important thing, and that was to discuss on a record by record basis the actual reasons for postponing each record.
Right.
And instead, what President Trump did is that he postponed, I think the count is roughly 45,000 records, which might amount to millions of pages.
Millions, sure.
But none of those records were individually identified, and there was no clear number of records. And so it's not really certain that President Trump even reviewed one single record, let alone approximately 45,000 records.
Right.
Guarantee he didn't review 45,000. Right? The guy doesn't read.
What Judge Napolitano said, though, it's not clear if that is backed up with any facts that President Trump actually looked at any single assassination record. So
right.
I am a little skeptical unless there's some kind of evidence that President Trump actually had his hands on any assassination records.
I'd be shocked. Let me ask a question, getting kind of a little bit backpedaling a little bit, and a question for kind of the layperson, though the person who doesn't know as much as those who are in the research community. What is the general, and we don't have to kind of get into specifics or names or anything like that, but what is the general consensus as far as what people think are contained within those documents?
Yeah, you may have to come back to your question. I want to make one really important point that kind of touches around the edge of your question.
Okay, sure.
So the JFK Act is really specific. Okay, the president only has authority to postpone what are called executive branch records.
Right.
The president has no authority over what the act terms as non-executive branch records. So executive branch records for which the president has authority over include all of the executive agencies, like the CIA, like the NSA, like the DOD. All of those are executive agencies. Okay. And so President Trump did not have authority under the act to postpone non-executive branch. And those non-executive branch records include congressional records. So the important congressional records that are in the collection include the House Select Committee on Assassination Records, the Church Committee records, and other like subcommittees of Congress.
Right.
Their records about the assassination. And what President Trump's orders in 2017 did is they had the effect of postponing a whole tens of thousands of unidentified records that no doubt included records that were not considered non-executive branch records. So he postponed congressional records, which is again non-compliant with the JFK Records Act.
Right, right.
So I just want to make that clear because that's one of the aspects of the lawsuit that wasn't initially pleaded but ended up going in, I think, on their third amended complaint. But really, all of those congressional records should be immediately released. One such record is an addendum to what's called the Lopez Report, which is a really detailed report about Oswald's alleged activities in Mexico City.
Right.
So there's a small part of the Lopez Report, which I believe is still being held secret. Jefferson Morley has been hot on the trail of the records dealing with George Joanides of the CIA.
Right.
Now, a lot of those records have been designated as NBR, which is not believed relevant to the assassination. I think over the course of the last decade, Jeff Morley has made it pretty clear that those records are not just relevant, they might be quite crucial in determining what actually happened in November 1963. So a lot of the records that are currently being held either partially or fully in secret are CIA files, FBI files. There are, I believe, some Secret Service files that are either missing or not accounted for. And so there's just, I think right now there's probably, by best estimates, about 4,000 to 4,500 records that are still either partially redacted or fully withheld.
And Andrew, those of us that really been doing a deep dive into this assassination for years understands how important Mexico City is to the whole story. It could be called the Rosetta Stone of the Kennedy assassination. And I know people like John Newman have done fantastic work in that. And so any records pertaining to Mexico City that are being withheld, I mean, they could be crucial in understanding the final puzzles of the pieces of this puzzle.
Yeah, definitely. And I mean, that really goes to exactly how these records are being kept. What the act says is that every single last record should have been released as of October 26, 2017. And again, I'll go back to the Section 6 criteria for postponement and their standards of proof. What essentially has happened since the Gannon memo and both the Trump and Biden postponements after 2017 is that the executive office of the president and now a court in California are essentially stating that despite the mandate of the act to release all those records and to have an extremely high threshold for keeping any record secret after 2017, that now the court and the executive office of the president are saying that despite this act, it's now easier, and the standards for keeping these records secret are way lower. In fact, there's no more standard of proof according to the presidents and to the judge out in California. So there's no standard of proof, and there's also no more Section 6 criteria. So after 2017, instead of becoming more difficult to postpone the release of the files, it's now easier to postpone the release of the files. And that goes directly contrary to what the JFK Records Act has said. Congress really should have stepped in at some point, to ensure that its own congressional records weren't withheld, but also to ensure that the president was complying with his ministerial duties. And while we're at it, the archivist too, because part of the problem with the records collection is that the archivist has failed to maintain a directory of identification aids for each record.
Yeah.
And in fact has failed to maintain identification aids for each record. So we don't know exactly how many records are being postponed and which particular records are being postponed. And those are also ministerial duties under the act.
And Andrew, I just want to throw this out. I know you don't like speculation, but conversation I had with your co-author, Professor Paul Blow. I don't know if it was on the episode that we had on, one of the episodes we had with him, or if it was a private conversation, but we were talking about, what could possibly be in those records. And he was saying how a lot of the travel vouchers are missing on some of these key CIA guys for the years 1963. So if you say like somebody who was, there's reports that like William Harvey was in Dallas days around assassination, and David Atlee Phillips and individuals like that. Like if you have travel vouchers putting those individuals in Dallas around the time of the assassination, I mean that's almost impossible to explain why somebody who's stationed in Rome, Italy would be in Dallas and the assassination, and the same thing like David Atlee Phillips or something like that. So, it's speculation at this point, but it's funny that those vouchers are missing for that year.
Yeah, I think you can add to that military intelligence.
Sure.
A lot of those records weren't disclosed in the first place. And whether they find themselves currently in the collection is another question. Yeah, I mean the two names that you raised, along with George Joannides'
Joe
entire
Needy, sure.
file.
Yeah.
Yeah, David Phillips, William Harvey.
E. Howard
I mean,
Hunt would
those
be another one.
key persons of interest for
Mhm.
sure. And having access to those files is critical to understanding what happened.
And we will be right back. DK's Corner, located on 802 East Lackawanna Avenue in Oliphant, Pennsylvania. Visit DK's Corner for hot and cold sandwiches, soups, salads, pizza, and delicious breakfast, including breakfast sandwiches, specialty coffees, and DK's Razzle Dazzle flavor shaken espressos. And take it from me, the best cheesesteaks around. Follow DK's Corner on Facebook and Instagram, or call them at 570-209-0278 to find out about their daily specials and catering. Check out DK's Corner, Oliphant's little hoagie shop. And we thank DK's Corner for sponsoring That's Enough Out of You. That's DK's Corner in Oliphant, Pennsylvania. Are you thinking about selling your house? Well, Bob Connors, a realtor at Christian Saunders Real Estate, says, I can't sell your house, but I sure as heck can market it and get it from sell to sold. Call Bob today for great marketing and to get a ton of eyeballs on your house. Are you in the market to buy a home? Not sure where to start? If it looks like something you shouldn't buy, Bob's going to tell you that. Think you can't buy a house or have no idea where to start? Been there, done that. Bob will get you going in the right direction. You can reach Bob at 570-614-3624 or 570-335-9000. And you can find Bob on Facebook at Bob Connors-Realtor. Whether you call Bob or not, please remember, stay awesome, all you awesome humans, and be kind to each other. Bob Connors, the realest real estater. And thanks to Bob Connors and Christian Saunders Real Estate for sponsoring That's Enough Out of You.
And Andrew, another thing is I've read a lot of these files. I go through a lot of these files, and a lot of them are tough read. They're really hard to sometimes put together the way they have them, the way they release them, and then they release some of them, that are repeats. And then the other thing is, so many of them are redacted, which makes it really difficult to read a lot of this stuff. And as far as the law, isn't it supposed to be released without redactions?
Yeah, unless they
Unless they can
find a
prove
way to justify the redactions. But
Right.
there's no justification at
No.
this stage. I mean, again, it was supposed to get tougher, not easier, for the government to keep withholding these records, either partially or fully.
Okay, so I want to get into a little bit about in the AARB we're going to get into, but before that, let's talk about what President Biden did then on June 30th, because it's kind of a mystery, because Biden, he has pictures of JFK and RFK all over the White House, and he says he's such an admirer of both of them and stuff. And basically, I think you said in your article on Kenny's and King, he basically took a flamethrower to the act of Congress. I mean, discuss what Biden did on June 30th.
Yeah, I mean, what President Trump did was bad enough via the Gannon memo, but President Biden kind of took it a step further by essentially attempting to rewrite the act. And I guess he's going to be successful at it unless Congress steps in. He virtually changed the standard of proof from clear and convincing evidence that a demonstrable harm to some specified element of national security would occur, to really what amounts to no standard of proof whatsoever. It's I'm just trying to find it in the article. I appreciate you mentioning the Kennedys and King article that I wrote about the Biden postponements.
Yeah, fantastic article. I recommend that to everybody, and maybe we could add a link to that, Billy.
Or of course.
Yeah, it's a bit of a long one, but it
Filled with important information.
Thank you. Yeah, you know what? It really does address a lot of the big problems. So instead of the clear and convincing evidence standard of proof that the act requires for the president to postpone any record, what President Biden basically did is he changed it to you can postpone these records when the, quote, strongest possible reasons counsel otherwise. And that's, I guess, President Biden and the agency's new standard. You know, the strongest possible reasons counsel otherwise. That's not really a standard of proof.
No.
And it certainly allows for what I would call arbitrary decision making. So not only do we not know exactly what records are being kept secret, they're also being kept secret based on criteria and a standard of proof that really don't exist under the law.
Unbelievable. It's really unbelievable.
And again, like President Trump, President Biden has completely failed to address the Act's requirement under Section 5 that a record by record review of each assassination record happen. He too has postponed an undisclosed number of assassination records and none of them are accounted for. And what Section 9D1, so there are three really essential provisions in the JFK Records Act. Section 5G2D, Section 6, and Section 9D1. Section 9D1, I spend a fair amount of time in my article discussing. That is the provision of the JFK Records Act that grants the president sole and non-delegable authority to postpone or release records after the Assassination Records Review Board has made their final determinations. And Section 9D1 says straight out that the Section 6 standard of proof is mandated on any presidential decision. He's got to give unclassified reasons for each postponement under the Section 6 standards. And he has to publish his reasons for postponing each record in the Federal Register, and that he has to issue an identification aid for each postponed assassination record. So those are what I would suggest, and so would the law, are ministerial duties on the president. So if the president is going to postpone any record, he has to follow those 4 or 5 ministerial duties set out in Section 9D1. And neither President Biden nor President Trump complied with any of those ministerial duties under the Act.
You know, Andrew, and it kind of ties into like a lot of what we say on this podcast and what I said recently on a podcast episode where, you know, the assassination didn't just, they didn't just kill the man, they killed the office of the presidency. And it's like, who's really running things? Is the president running things, or is he just doing what he's told? And that's the frustrating thing with this whole thing, like this whole mess. It's frustrating.
Well, I mean, now that you bring it up, President Biden really did kick over his legal duty to perform his ministerial duties under the Act. He kicked it over to the agencies. So now, if you look on the national,
agencies are going to do, right?
If you look at the National Archives database of records. It was shocking to me back in 2021. I think I probably was the first researcher to notice that National Archives had changed their entire database, and under the postponement criteria, they literally changed it to say release upon the approval of the CIA.
Oh boy.
Oh man.
And you know what? I took a screenshot of that because knowing the JFK Records Act, the president can't delegate his authority to approve the release or the postponement of these records. And to see it just flat out stated, approval of the CIA, that's the postponement criteria.
Oh, talk about
It's
the
like,
fox
my
in the hen
God.
house.
I just, you know what? President Biden was a senator when the JFK Act was passed by Congress.
And he voted for it, right?
Everyone did. It was
Right.
one of the few pieces of legislation that was unanimously passed by both parties.
Mhm.
And yes, President Biden voted for this. And now that he's president, I guess things have changed.
Wow. So, Andrew, let's get into the ARB. So, the Assassination Records Review Board, there's supposed to be periodic reviews, right? So, my understanding from 98 to 2017, there's been no periodic reviews, correct?
Yeah, I don't think that is 100% correct. There's
Okay.
been virtually no meaningful
Okay.
periodic review. Now, the act is very specific in sections 5 and 9 that after the Assassination Records Review Board has done processing and postponing certain records, that there would be a process called periodic review to go over those records. Now, what a lot of researchers don't know is that as the ARRB was reviewing and postponing records, they created a file called a final determination notice. And this final determination notice is different from an identification aid. The two documents look quite similar, but what the final determination notice did is it created a paper record of what in administrative law they call a final decision. And a final decision can be reviewed by the court under judicial review. So it's a legal process. It creates a final decision on an administrative level that can be reviewed by the court. And what these ARB final determination forms did is that they very specifically laid out the Section 6 criteria for postponement for each record on a record-by-record basis. But more importantly, the ARB put in writing its recommended release date for each record and what the suggested trigger for the release was, whether it was a release date or an event that triggered the release of each record. So let's say like they had a final date in mind where they thought all relevant individuals would likely no longer be alive. Thinking that maybe the youngest person involved in the assassination might have been 20 in 1963. They set out a future date that in all likelihood individuals would be deceased. And for each record, they might have even looked at the age of each individual intelligence asset that might come into play under Section 6. And they created a date for the release of the file that dealt with that individual. And it was those triggering dates or events that should have led to the periodic review of each specific record. Okay. And really those final determination forms were the roadmap for releasing each assassination record. And for whatever reason, NARA did not coordinate that periodic review as they were required to with the agencies under sections 5 and 9 of the Act. And what that led to was a massive glut of unreleased records as of the deadline for release in 2017. Now, the agencies probably took advantage of that failure to conduct periodic review, but again, it was a failure on the part of NARA to do their ministerial duties that they were required to do under the Act.
And the thing is, Andrew, like for people listening at home and maybe they're not as familiar with this case, just you got to ask yourself, the media is out there, the mainstream media is saying this was the act of a lone gunman. The government's official position was it was a lone gunman. I mean, why would there be national security concerns in connection with an assassination that was reportedly carried out by a lone gunman? I mean, that's the thing that people got to ask themselves. Why would there be any files hidden, and what is the national security interest in a lone gunman assassinating a president?
You would think that if the government's official story that Lee Harvey Oswald acted alone was true, that it would be in the government's best interest to release all those records, because those records should theoretically support their official story. The fact that that there's still thousands of records still kept in secret makes it very easy to draw a negative inference from that.
Right. Andrew, I want to read you two things. One is a record, and then I want to read you something from the book, and I want you to comment on it. This is the record states the president only has the authority to authorize continued classification of an assassination record if he certifies that each specific record continues to pose an identifiable harm to the military defense, intelligence operations, law enforcement, or conduct of foreign relations as required by the Act, and that such unidentifiable harm is of such gravity that it outweighs the public interest in disclosure.
Right. That's what, section 5G2D, right?
Yeah. And I mean, none of this is they're not given any reasons for this on holding these specific records.
Now, so the problem is that I don't remember if you read the very beginning of section 5G2D, but the very first word of that provision is the word each. I don't know if you see it there in front of you, or you're taking just a smaller.
No, I just took that
later section.
Yeah.
So the word each, the way statutory interpretation happens is that judges and the courts have to give meaning to each word. And since the word each is at the very beginning of that provision, it applies to the rest of that section. And it requires the president to give to give reasons. And even the basic principles of administrative law, a decision maker has to give adequate reasons for any decision under law.
And that's reasons on each specific record, correct?
That's right. Yes.
Okay.
Yeah, and so it's hard to wrap your head around the president, both Presidents Trump and Biden, just given a blanket postponement to like an undisclosed number or an undetermined number of undisclosed records. It's like that decision, A, has no reasons, it has no parameters, and it doesn't allow any individual to appeal anything, which is kind of an abuse of fundamental justice. You have to be able to appeal something. But if a decision maker doesn't give adequate reasons, it makes any such appeal impossible which is a violation of due process. Does that make sense?
Yo, it makes perfect sense. It makes perfect sense.
I don't know if it answers your question though.
No, you answered it. You answered it. I mean, I just wanted to hone in on the specific, you mentioned the word each, and it's each specific record. There needs to be a reason why these records are being withheld.
The act doesn't make sense unless it's done on a record by record basis.
Right.
And I mean, right up to 2017, everything was done on a record by record
Yes.
basis.
Yes.
And I mean, what the agencies and President Biden and President Trump want us now to believe is that after 60 years since the assassination, our standards are less exacting and less onerous for the executive office of the president to postpone these assassination records than they were even before 1992. They can be completely arbitrary because there's no standards of proof, there's no postponement criteria, and they don't even need to identify which specific records or make a record by record determination like they used to before 2017. It guts the act, and the whole purpose of having, and again in section 2 of the act, it sets out the purposes, and the purpose is to have an enforceable, accountable statute for the ultimate release of every single record. And it seems that is not happening.
Now I want to read something directly from the book. It says, there is no reasonable or legal reason to continue 60 years of government secrecy regarding the JFK assassination. That is why this is a chokehold. The more that time goes on, it becomes more and more obvious that, in all probability, the government is covering up a domestic intelligence operation that backfired in Dallas, or even worse, a calculated plan by intelligence assets and the Pentagon to remove JFK from office in a way that could deter future presidents from trying to actively manage U.S. domestic and foreign policy. I mean, that part of the book to me is phenomenal. That's paragraph right there just sums everything up. It's in why this whole thing is a chokehold.
Now, I can't take credit for that. I believe that's probably in Jim D'Eugenio's final.
Yeah, I think it was
final
Jim.
conclusion, but
Right.
I mean, Jim has done an excellent job in encapsulating
Yes.
all of the various parts of the book in his conclusion. And I mean, the last chapter of Chokeholds deals specifically with evidence of an ongoing operation to obstruct justice.
Right.
And I think it's one of the more powerful parts of the book. Paul Blow did a wonder. He did most of the work on the final chapter. I played a smaller role, but and dealt particularly with the Biden and Trump postponements. But that last chapter sums up all of the government's efforts to really put a lid on on the records coming out, the truth coming out, and it really is a stark, just such a stark, problematic conclusion to this book, and it becomes really obvious when you see the efforts. Like again, the Trump and Biden postponements are just the last part or the most recent part of a clear effort, whether it's through the media or whether it's through even the House Select Committee on Assassinations. I mean, the information that the ARB released about the Bethesda witnesses, which the public were always told, hey, the Dallas doctors were wrong. They never really examined JFK's head wound. They never looked at his back. They weren't trying to determine causes of death. They were just treating President Kennedy to try to save his life. So they never really knew what they were talking about. the only people who really knew what they were talking about were the Bethesda witnesses, whose evidence completely contradicted the Dallas doctors. Well, after the ARB released all of the information from the Bethesda autopsy, the fact is most of the Bethesda witnesses, including doctors, including orderlies, including the medical staff and corpsmen who handled President Kennedy's body, the fact is they corroborate the Dallas doctors. They don't refute or
Absolutely.
contradict the Dallas doctors. That, to me, why wasn't that reported on by the mainstream media? That is a shocking dereliction of the mainstream media's job to tell the truth. And instead, it was suppressed. And you only hear about it on podcasts or on the odd website that covers it. There's been a lot of fantastic work that has shown, like Doug Horn. I don't know if you've ever had Doug Horn on your show.
No, we
But
haven't had a pleasure yet.
The work that Doug Horn did for the ARRB,
Tremendous.
along with Jeremy Gunn,
Right.
that alone, you could look at that. And I know that I think 2 chapters of our book really touch on, and I mean, we're standing on the shoulders of giants who really interviewed the Bethesda witnesses and
Right.
got a hard handle on what actually happened at Bethesda. And I mean, that's just one out of many indications that there was obstruction of justice. And it looks like the House Select Committee on Assassinations buried that story, and they continued the fable that the Bethesda witnesses refuted what the Dallas doctor saw.
Unbelievable.
And we will be right back. And we would like to thank our sponsor, Gracious Day Grains. Sean, you like to eat healthy, don't you?
Always, buddy. I try to eat healthy as much as I can.
Yeah, and there is nothing healthier than what they call like farm to table, right? So when you can get something right from the ground and make it and then put it right on your table. And Gracious Day Grains, they have a tremendous selection, and it's totally organic. Everything is, they don't use any sort of herbicides or pesticides or anything like that. They have a bunch of different products on their website, Gracious Day Grains. So if you go to graciousdaymilling.com, you'll find a bunch of great stuff there, Sean.
Yeah, you will, Billy. And it's owned by Tom Maxey, who's a great guy from Virginia. He's a truth seeker, just like me and you, buddy. And Tom's growing philosophy follows the wisdom of farmers of centuries past. And a quote from Tom is, "If we practice the right rotations, we exclude the bugs and weeds without needing herbicides or pesticides." So, I mean, this is great, Billy. I mean, what he's doing is fantastic.
There's cornbread mix, there's cornmeal, popcorn he sells, buckwheat Sean, have you had buckwheat pancakes?
No, buddy.
Oh my, they're delicious. I love buckwheat pancakes. And Gracious Day Grains sells buckwheat pancakes. Just go to their website and you'll be able to find all of this stuff there. You can order it right off the website. You can find out all about how they farm and their whole philosophy, Tom's philosophy. It's great stuff.
It really is, Billy. And one of the things he does is he grinds small batches at very low temperatures, which retains the flavor and the freshness.
Of course. And it can't get any fresher than that. I mean, it's literally right from the ground. So again, go to graciousdaymilling.com and just, take a look on there. You can order whatever you want and they'll send it right to your door. Again, it doesn't get any fresher than that, right from Tom's farm to your door to your table. So
absolutely. And eat healthy and you'll feel better.
Absolutely. I wish I could do that. I wish I could eat healthier, Sean.
We'll start with Tom's stuff, buddy.
I'm going to order some of those buckwheat pancakes. I love
There you go. I'm going to try them too, Billy.
Yeah, they're really good. All right. Gracious Day. We thank Gracious Day Grains for their sponsorship.
Thank you.
Hey, Andrew, real quick, getting back to the book Chokeholds, Could you talk a little bit about how you got involved with that book and with those authors?
Yeah, sure. I had been working with Mark Adamczyk on researching and drafting the original complaint that ended up being filed by some other lawyers in the Northern District of California. And so I had known and worked with Mark for probably about 2 years, and Mark traveled down to Dallas in 2022, I think November 2022, for a COPA conference, and he met Jim D'Eugenio there. Mark's written quite a few articles for Kennedy's and King for Jim D'Eugenio's website, and so Mark met up with Jim, Paul, and Matt Crumpton, the other authors of the book. I wasn't there for that conference, and they kind of formulated the concept for the book, and Mark suggested to the other authors that that I get involved, and they reached out to me, and we quickly collaborated on framing up the concept for the book. And my focus, guys, I'm sure you can probably tell, I'm interested in the assassination. I'm very interested in all the facts and evidence of it. But again, my interest was really largely around the legal aspects, and that's what I put. My main contribution to the book is outlining the standards of proof in the introduction to the book, and then working with Paul in the final chapter to kind of do a summation on obstruction of justice in the final chapter.
Well, Andrew, go into that a little bit deeper, like the legal framework of how you guys wrote the book, and then the standards of proof.
Yeah, you know what? Like I didn't know this when I started, and so I really wanted to take a fresh look at the Warren Commission, the House Select Committee on Assassinations, and so I mean, previously I in my legal studies I had written a paper about standards of proof in law school, and it's something that I was kind of fascinated how it worked. I've sat on tribunals, and I've been active in all kinds of different litigation. So standards of proof are a pretty fundamental part of the practice of law, at least in litigation. And so I wanted to see what kind of standards of proof were applied at the Warren Commission, House Select Committee, and I knew about the ARB because I'd been studying the JFK Assassination Records Act. But so I dug into the Warren Commission, and I was shocked to find they never applied any standard of proof at all. They talked about it a little bit, and then they decided, well, we're not going to have a standard of proof. We're not a court of law, and we're going to listen to hearsay. There's going to be no cross-examination. All of our hearings, or most of our hearings, are going to be held in secret. And then our findings, the American public should take our findings as the bedrock of truth. Yet we're not going to have any standard of proof on which we're going to be held accountable. And I'm thinking this is crazy, because the whole point of standards of proof is to provide some level of confidence, reliability, and certainty that the decisions being made are actually based on sound legal principles. And to find out that there was no standard of proof at the Warren Commission, it was unsettling. So I decided to look at the House Select Committee too. And I was even more shocked to find that there were no standards of proof at the House Select Committee. Now, what this does is it allows for completely arbitrary decision-making. You can include or exclude evidence. You can give evidence more weight or less weight, and you're not held to any level of accountability. So it's completely arbitrary, the findings that come out of a process that has no standard of proof. And I'll tell you, from my experience practicing law, even the most loosey-goosey, low-level administrative tribunal. Now, that administrative tribunal sounds pretty serious, but we're talking like a low-level community groups discipline proceedings. They have to have a standard of proof. And when you think about a commission, a federal commission appointed to determine the cause of death of a president not having any standard of proof, it would be laughable if it was funny, but it's not funny. It's serious. And so I looked at, okay, what's some of the history? And this is probably, I know Jim Diogenio likes this part of the book, and maybe you've discussed it with him, but there was a book called The Origins of Reasonable Doubt by James Whitman. And I just love the historical underpinnings for the beyond a reasonable doubt standard of proof. Back in the really old days, when the whole justice system was just being created, it was a mortal sin to wrongfully convict someone. And so in order to get a jury that was willing to sit in judgment of another person, this made people really uncomfortable because they didn't want to go to hell for wrongfully convicting someone. And so they created this reasonable doubt standard of proof, basically to protect the souls of people sitting on a jury. And I thought, wow, this is pretty fun when you apply it to the Warren commissioners, and the fact that they had no standard of proof, and they really wrongfully convicted Lee Harvey Oswald for committing at least one and probably two murders on November 22nd.
Well,
and then
Andrew, go ahead. I didn't mean to cut you off. Go ahead.
Yeah, that's okay. You know what? I'm happy to answer what you want. I was going to talk about some of the other standards of proof, but it's legalistic. So if you want to move to a different topic,
I just wanted to throw a comment out there. Just basically, it goes to show you that the Warren Commission was exactly. It goes back to the discussion with Hoover and Johnson and Katzenbach, and they're talking about, Johnson says we got to take this out of the realm of a communist conspiracy, and Hoover says, then we need to convince the public that Lee Harvey Oswald is a lone assassin. Well, that's what the Warren Commission was designed to do. It was designed to convince the public that Oswald was a lone assassin, not that he was the lone assassin. And that's what they went into this whole commission. And it goes to the obstruction of justice. Just putting Alan Dulles on the commission itself is an obstruction of justice. And then to have him handing out, books on that all political assassinations are the work of lone gunmen, and he's handing it out to the people on the commission. I mean, he's tainting the jury, so to speak, right from the beginning, and that's an obstruction of justice.
Yeah, there's a lot to suggest that the Warren Commission was a public relations exercise.
Sure it was. And you think about Jim Garrison, who really was the first person to be, hypercritical of the Warren Commission. And just imagine him, an attorney reading through that, what he must have been thinking and just going crazy. It's not hard to see how he kind of became obsessed with it and just, reading it and pulling it apart. Just amazing. Unbelievable. When you think about, this was a coup. This was the killing of our leader, and our government, to this point has not told us the truth about it. And it just seems like they never will tell us the truth about it. They're just going to keep covering it up and delaying these documents from being released. Amazing. Andrew, quick question for me. I mean, do you think we will ever see these records? Do you think in our lifetime we will see them?
Yeah, really, that depends on two things. That depends on people being successful in court, or Congress taking up its mandated responsibility to provide oversight over the JFK Records Act. So those are really the only two avenues that will force the government, mainly the executive office of president and the agencies, to comply with the people's will through the JFK Records Act. So there's court and there's congressional oversight. And right now, I don't have much hope for either avenue succeeding.
Right. Doesn't seem like it.
Well, Andrew, go ahead and say what you were going to say. I didn't mean to cut you off before.
No, not at all. I found this history of the standards of proof and the JFK Records Act and some of the underpinnings of the reasons why the American system, because remember, I'm Canadian, this was really just such a fascinating pathway that the JFK Records Act led me down. And from those early religious underpinnings to the beyond a reasonable doubt to some of the other standards of proof. I mean, the key aspect of the standard of proof is really to give so that people aren't wrongfully condemned to life in prison or the death penalty, that someone's only convicted of a crime if there is proof beyond a reasonable doubt. But really, the key aspect to it that I think applies in the JFK assassination case is that it's really fundamental to a democracy that its people have faith and confidence in their justice system and in their system of government, and that you have to be absolutely certain when you're going to convict someone of a serious crime. And neither the Warren Commission nor the House Select Committee on Assassination rose to any level of standard of proof in coming to their findings. And I think the result of that, you can feel it in the American public. Still, a very, very significant majority of Americans do not believe that Lee Harvey Oswald acted alone, and a good percentage of Americans don't even think he acted at all in the way that's being suggested by the two main government investigations into the assassination. So I think not having a standard of proof in either of those investigations was a fundamental failure that's led to this this state of being. And sadly, I think America really did change in 1963, and there was a substantial loss of faith in the entire system. And that saddens me. Like I love America. I think the United States is one of the great countries or great states in the history of the world, and that's because of what its system of government, the ideals that it represents, and for that to be challenged by potentially a group of people that want to suppress the truth is it's difficult, because I think what America stands for is far greater than that.
Yeah,
Continue for that. They have to come out with the truth of what happened here. And I'm like you, Andrew. I don't have much faith in Congress.
No, they've certainly been made aware of the problems with both President Trump and President Biden's decisions. they're aware of it. They
Right.
should be aware with this court action that that the both presidents have postponed congressional records. And again, the title of my article for Kennedy's and King is about the president usurping Congress's authority. So it's not only Congress's authority that mandates the release of all the records, but President Biden and President Trump have usurped Congress's authority to control congressional records. And in my view, Congress should be very, very protective over maintaining control over its own records. And that alone should trigger oversight hearings. But, 2017, what is that? That's a few years ago now. They've had time to do something and they haven't acted. So I guess having control over, they've granted control over congressional records to the presidency.
Well, Chuck Schumer made a comment, Andrew. He said that, Congress should use the JFK Act as a model for new legislation on the issue of UFO sightings. And, this is how ridiculous this is. The government has had this thing lately where they're kind of admitting, the UFO sightings and stuff, and yet they still are pushing this fairy tale of the Warren Commission and the Oswald Montgomery theory, and it's just unbelievable to me. And this is why I just have no faith in Congress doing anything about this.
Yeah, you know what? Like I don't know how I feel about the whole UFO thing, but I think Senator Schumer is doing some next level trolling by suggesting that the JFK Act is a model for any kind of legislation, at least. But I mean, maybe you should start to do some oversight on the JFK Act before he makes
Yeah,
that
exactly.
kind of equation.
We should tell the truth about what happened to Kennedy first, and then we'll worry about the gray aliens later.
Exactly. Yep. I agree with that.
But Andrew, is there anything else in the book that we didn't discuss? Anything that you contributed to that you wanna discuss with us now?
No, you know what, guys, I think we've dealt with quite a lot of territory here.
Yeah, we have.
The book was, I got to say, a real opportunity. I'm just really proud and pleased to have been able to work with such a great group of guys. Any project, even Matt Crumpton, who like me, was a more junior member of this group. Jim DiEugenio has been around the block and has done he's got a tremendous history of work in the JFK assassination. So it was a real honor getting to work with Jim and getting to know Jim over the last couple of years. And same with the rest of the guys. Like Paul Blow is an extraordinary researcher, and I hope you've had Matt Crumpton on, so I don't think
Yeah.
you're anti competition here. But Matt's podcast and YouTube channel, Solving JFK, he has done some incredible work. And I highly recommend anyone, aside from listening to your show, to take a listen to Matt Crumpton's
Absolutely.
Solving JFK
Yeah.
podcast.
And there was a great conversation with Matt. I mean, we really went into the Oswald impersonations really deep, and we're getting
He's
so
done
much
some
feedback.
incredible work. Matt
Yes.
is something else. Yeah, not just on his show, but his contributions to the book were incredible. I've got to say, anyone who's wanting to read the book, Paul Blow's first chapter on in the book, which is what the insiders actually said.
Right.
There's some misunderstanding with that chapter, and it's a fairly lengthy chapter, but that chapter, I think, more than any other chapter, has grown on me the more I realize how important it is that the people who were on these commissions, like the Warren Commission and the House Select Committee, the ARRB, people in the FBI, Dallas police, we're talking the most inside of insiders, members of Congress.
Right.
That first chapter of the book really puts a dent on all of the deniers of a conspiracy, either to obstruct or to actually commit the assassination. That first chapter outlines so many insiders on these commissions and investigations
Yeah.
that all say that there was a conspiracy. So it's kind of hard to listen to denier authors
Sure.
that deny that anything other than Oswald acting alone is the truth. A majority of insiders, including multiple Warren commissioners,
Exactly.
never believed the lone nut story. So
no. Richard Russell didn't believe it.
Hale Boggs.
I mean, even Gerald Ford made comments later.
Yeah,
and even Arlen Specter. I mean, when he makes the comment about the magic bullet and he was running it by them and they didn't believe it at first. And he said, it's either this or we have to go looking for another gunman. So even Arlen Specter didn't believe his own magic bullet theory.
The most hardcore lone nutters, privately and on the record, have acknowledged that there was more than likely a conspiracy. So anyone who's made to feel like they should put a tinfoil hat on only need to read the first chapter of Chokeholds to understand that that's a really bogus argument that conspiracy theorists are off base.
And when somebody is legitimately looking, at investigating a case like a Jim Garrison, he gets attacked by, the Get Garrison group, and even on the HSCA, you had Dick Sprague and Bob Tannenbaum originally, and they weren't going to use the FBI or the CIA. They were going to do their own investigations, and they were going to go after the evidence wherever the evidence led them. And of course, they got ousted because of that.
Some people haven't lasted long, that's for sure.
No, and then of course they put Joanides in there to make sure that the investigation pretty much was paralyzed.
Yeah. It's that's all in our last chapter, and that again, I think the first chapter, all the chapters are fantastic, and some people are having they see too many names, and it's for some it's a tough read, that first chapter, but I really think when you put it into the context of even the strongest lone nutters, they stated publicly and privately that there was a conspiracy. I think that's like one of the biggest chokeholds going, and that chapter is a great chapter.
I agree. And the entire book is tremendous. I recommend it to everybody, and we have it up on our bookshop, and anybody that wants to get it could get it on our bookshop. It's tremendous. Recommend it to everybody.
Well, guys, I really appreciate you having me on and the other authors. It's been great talking to you. I appreciate the chance to talk about both the article over at Kennedy's and King and JFK Assassination Chokeholds.
Well, thank you, Andrew. Appreciate it.
Yeah, we appreciate you coming on and taking some time with us to go through this and explain it. And it's just such a it's so frustrating, when you know that there's this information, a treasure trove of information that could tell us the truth, what really happened, and we may never see it. So
guys, the legal aspects are, it takes a little bit of time to wade through and understand how they interplay with each other. But I do recommend that your listeners take a look at the JFK Records Act.
Yes.
Read the article at Kennedy's and King, because it lays it out in a way that if you slow read it, that you start to understand how offensive what's happened over the last 5 years, 6 years, the decisions with regard to these assassination records and the continuing secrecy around the assassination. It should get people a little bit upset. A lot of your listeners might not have been alive in 1963, but hey, it's still their government.
Sure. Well, it's supposed to be.
Keeping information that really, by law, should have been released back in 2017, continuing to keep it secret.
Yep.
And so if they have an interest, take a look, go through it. If they feel motivated, Congress is one avenue that has oversight over this, and I highly recommend that people write a little note to their congressperson or senator and say, hey, release those records, do some oversight on the JFK Act. We need it.
Right. Agree with you. All right. Andrew Iler, a co-author of the book Chokeholds. Thank you so much for coming on. That's enough out of you. We really appreciate your time today.
Thank you, Andrew.
All right, guys. Have a good week.
You too. Take care.
Ciao. Thank you.
That's Enough Out of You podcast is executive produced and written by Bill Rader and Sean Kane and edited by Bill Rader. The That's Enough Out of You podcast and logo are exclusive property of Bags of Chicken, LLC. Any rebroadcast, retransmission, or accounts of this podcast without the express written consent of Bags of Chicken, LLC is prohibited. So don't even try it.